Good evening, everyone. A very warm welcome to one and all. On behalf of IPNet Southern Region, I am Suhasini Ashok. I welcome you all to today's webinar on the topic Section 29A Red Flags, Legal Interpretations, and what IP must verify. So, we take pleasure to have with us our distinguished guest speaker, Shri Charan Singh Sir, a retired NCLT member. Sir, your presence and experience sharing will add huge value to this session. And I'm delighted to welcome you all today's webinar. This is the 41st webinar in the series of webinar organized by IPNet. This is your own platform for sharing knowledge and experience of the IBC ecosystem in India. So we are privileged to have the guest speaker Shri Charan Singh Sir, retired Honorable NCLT Technical Member Hyderabad, as our esteemed keynote speaker on the topic. And Mr. Charan Singh Ji is a distinguished banker having close to 36 years banking experience, rich experience, and handled various critical issues at NCLT. We can have a great learning on practical issues relating to Section 29A from Sir. Also, we have speakers from industry, Mr. Prakul Tadi and Mr. Lalit Mathur as lead speakers. So I extend my special thanks to Ashish Makija sir, who is president of IPNet, for bringing all of us together. IPNet is a robust platform. The membership link is available in the chat. We look forward to those who are not yet joined the IPNet as members. So IPNet has become a vibrant community for insolvency professionals across India, fostering continuous learning, collaboration, and professional growth. So we are committed to supporting IPs through expert-led learning activities like webinars, study groups, practical guidance on IBC-related challenges. This is a dedicated member portal offering comprehensive resources. For those who are already part of IPNet, we thank you for your support. And for others, we encourage you to join this dynamic and ever evolving network member. And the membership details are available on the chat. So thank you for all being here. Let's make this session insightful and rewarding. Now, we will play the IPNet intro video.
In the fast-evolving world of insolvency and bankruptcy, professionals need more than just knowledge. They need a strong network, continuous support, and a unified voice. As the challenges of the insolvency profession grow, so does the need for a platform where professionals can come together, share their experiences, and find collective solutions. That's why IPNet was formed. Promoted by Transition, IPNet is more than just a network. It's a mission to unite insolvency professionals across India, empowering them with the tools, knowledge, strong leadership, and community support they need to excel. Our purpose is simple: to create a cohesive community of insolvency professionals that stands strong together, advocates for their interests, and drives excellence in every aspect of the profession. At IPNet, we believe in continuous learning and collaboration. Our activities are designed to ensure that every member stays ahead in their field. From specialized study groups that dive deep into critical topics like CIRP, compliances, and many more, to webinars and workshops that bring the latest insights right to your screen, IPNet is your gateway to professional growth. Backed by Transition, a leader in insolvency training and resources, IPNet is committed to promoting the interests of insolvency professionals. Our goal is to ensure that every IP, no matter where they are, has access to the best resources, strong leadership, and a network that truly understands their needs. Join us in this mission to build a stronger, smarter, and more connected community of insolvency professionals. Together, we can overcome challenges, shape the future of the profession, and make a lasting impact. IPNet, National Network for Insolvency Professionals in India.
Now I invite Mr. KB Kumar sir, who is retired AGM Bank of Baroda and former assistant of Registrar of DRT Hyderabad and NCLT. Sir, please introduce our guest speaker, Shri Charan Singh sir.
Okay, thank you, madam. Good evening to all the participants. I am very much privileged to introduce Sri Charan Singh sir, who was former technical member of NCLT Hyderabad. I also inform you that I was associated with him for 2 years in NCLT Hyderabad as Deputy Registrar of NCLT Hyderabad bench. He is very clean, very simple and down to earth personality. He is also very spiritual, as I experienced with him with the spirituality. And with respect to his educational background is concerned, he has done his MSc in rural development and agriculture economics. He is also certified associate of Indian Institute of Bankers and IICA certification for independent directors. I also inform you that he is registered with IBBI as an insolvency professional. He started his career in Bank of India as an agriculture officer and worked various parts of the country, including overseas assignment at Kenya in Nairobi. And during his 30 years experience at Bank of India, he also worked as chairman of Grameen Bank and work posted at Lucknow. And after tenure in Bank of India, he joined as an executive director in UCO Bank. There he worked for 5 years, from March 2015 to March 2020. During his 36 years of rich experience in banking and finance, he was having board level experience. Board level experience means apex body of the banks. And he is having experience in board level at 7 to 8 years. And after that, Government of India has selected him as a technical member, and he joined at NCLT in New Delhi on 18th November 2022. Thereafter, he was posted at NCLT Hyderabad and joined with NCLT Hyderabad on 5th December 2022. Up till then, up to 30th June, he has been delivering so many judgments, particularly with respect to 240 and 241 matters. And he is also having, during his career, he worked in all geographical areas, including overseas assignment. And he is also spiritual, and he has been practicing meditation with Ramakrishna Mission and presbyter for the last 5 years. Thank you very much, sir. With this small introduction, I thank Ashish Makija sir for giving me this opportunity, and to all the IPNet members who has participated. Thank you, sir.
So we welcome Charan Singh sir to address the IPNet members and the other professionals who are joined.
Madam, most probably, sir has just logged out due to some technical problem in his system. He'll be joining us soon.
So kindly bear with us. Charan Singh sir is joining. Due to some technical issue, he has left the meeting. Yes, sir.
Welcome back, sir.
Sorry,
Welcome
I
back,
was
sir.
disconnected because of some electricity failure.
No issue, sir.
No,
Please.
sir.
So can I start now?
Yes, sir.
Yes,
Sure.
sir. Yes.
Okay. So good afternoon, everyone.
Good afternoon, sir.
Thank
Good
you.
afternoon.
First of all, before starting,
Good
I
afternoon,
thank.
sir.
Good afternoon. Good afternoon. So I thank you, Mr. Makija and all IPNet officials for giving me an opportunity to interact with all of you this afternoon. And it's really good that after retirement, after a very short period, I'm able to interact with all of you. And I really appreciate the topic chosen is also a wonderful topic. It's a very vital topic as far as IBC is concerned. So before we go ahead on this section 29A, I would just like to give a brief background about how this IBC and came into being, very brief. And then, of course, section 20. See, in fact, it's most of the bankers and the persons who are involved with the economy, they might be knowing that Indian economy was growing at a very high speed. The average growth rate was around 8.8%. And during that period, so many new entrepreneurs, new persons, and even overseas investment, they came to create new capacities in various fields, particularly the steel sector, cement sector, road, and all that. So, a lot of expansion of industries was taking place during that period. But unfortunately, this 2008, the global financial crisis crept in. And that created a problem for the growing industry. And in the next year, 2008-9, it was like a contraction in the GDP. And then to counter that, RBI took so many measures to relax monetary policy, and a lot of liquidity was infused in the market to land. And there was almost a pressure. I remember those days, 9, 10, and 11 also, to lend more and more. So a lot of lending took place, but unfortunately, because of this global slowdown, these projects could, and of course for some judicial intervention also, like that 2G spectrum cancellation, that coal block allocation was cancelled. So many that type of decisions came. So a sort of policy paralysis crept in the system those days. And most of these big projects, they got delayed. And when they got delayed, there was a cost overrun. And the whole economics of these projects failed. Some of of course, the promoters, they siphoned off some money also out of the financed money. And that's how a lot of non-performing asset was created in the system. The bankers were saddled with lot of NPAs. And during that time that Mr. Raghuram Rajan was the RBI governor, he came out with a scheme of, and banks were not, of course, trying to not declare that NPA, trying to keep it evergreening. But then he came out with a scheme, AQR, Asset Quality Recognition and Asset Quality Review, AQR scheme. And the bankers were forced to declare those accounts as NPA, which were really not performing well. So that resulted in a huge NPA in the balance sheet of the banks. And almost most of the banks, they were just the whole this net worth was almost eroded. The government recapitalized, and a lot of funds was infused by the government. So with this background, then government thought of bringing a lot of this discussion was happening, how to bring back this money and how to these projects which have become unviable, though they are good projects. A lot of money has been invested on them, public money. So how to bring them back to life? Lot of discussion took place during that period. I was also a part of that discussion in Kafra, the training college of RBI. Ms. Usa Thorat was the principal of Kafra at that time. And we, group of 5, we discussed on this, how to come out. And at various levels, this discussions were taking place. And with that background, the government thought to bring this IBC with a creditors control centric thing. So that was the theme that, okay, when the promoters, they are not able to run, they are not doing the things what they have to do, let the creditors take control through some other third person. And that other third person was RP. So all those with this background, this IBC came into being, just to revive all those industries which have failed because of some external circumstances, because of some internal circumstances as well. And then so this IBC started. And the main theme was that it will be a creditors control regime in this rehabilitation of those industries. But what happened when the things started taking place? Some of the promoters, they really tried to play smart, and from the back door, from the related parties, somehow they again wanted to take control of those units which already they have spoiled through their misdeeds or through their ineffective management. So then again, this jurisprudence, and then mostly I think this started with that SR case, because they tried to take over through some there. So at that time, this 29A was introduced to prevent, it was a sort of barrier to prevent the promoters who, in a way, in most of the cases, not all cases, some of the cases were have become NP or have gone bad only because of the external circumstances as well. But most of the cases were because of their bad deeds. So then this 29A government came out with this program, with this provision, and that's how this was. So that was the background and rationale to introduce this section 29. Basically, to keep the creditors in control of the resolution process of corporate data. And because this promoters were trying, they have created in contributed in various ways to the deterioration of wealth, but instead of that, they were trying to get back into those industries. And one interesting thing was that in most of these industries, the promoters' stake was not that high. Maximum 25%, maybe 20% in some cases, and out of that also, they have taken back some money through some other things. 75% was the lending. So basically, to revival, of course, was the biggest stakeholder were the public sector banks or the private sector banks or the financial institutions. So naturally, it's logical that they should have control of the whole process. So that's how this section 29A was brought, and some of the persons were declared that they will not be eligible to apply as resolution applicant. You all know that undischarged, insolvent, willful defaulter. Willful defaulter, as per RBI, some persons are declared as willful defaulter. So, and then this NPA concept, that was a biggest thing, this NPA. So many things have gone into after that also. That if NPA is there and if he clears, what happens? So again, an amendment was brought in that, okay, if he clears, we can allow. And then the NPA, age of the NPA, it should not be, if suppose only a few days back the account has become NPA. So whether he can apply, so a 1 year cap was put in that, okay, 1 year NPA it should be. So many things were there in this particular subclause. And then of course some of they should not be punished, they should not have been convicted for any.
Sir, unfortunately, you are muted, sir. Kindly unmute yourself, sir. There is no still, sir.
Sir, you are on mute, sir. Charan.
Now,
Yes,
Yeah,
now
yes, yes.
yeah, it was only for few seconds only, sir.
only for a few seconds. Okay.
Yes, yes.
So where up to what level you have heard me?
Sir, the promoters,
The
the promoters.
background I was telling how.
Yeah, it was all clear, sir. You were telling us
So-
about the promoters.
You are
What's that?
telling about the promoters, how they were controlling.
Yeah, promoters actually this when this IBC came into being and this resolution process started taking place. So some of the promoters through backdoor entry, they tried to take control of their units. Though their stake was minuscule and they wanted to take it at a discounted price. So to prevent all that, to plug that loophole, this section 29A was brought in. All of you must be knowing. The rationale and the background, the purpose of bringing is in this 29A was just to stop some type of resolution applicant that they cannot be taken as a resolution applicant. So I was just telling that you must be having that section 29 and A and all those persons who are not eligible to participate as resolution applicant. A is like undischarged insolvent, B is willful defaulter. So I was telling that C, this is the most important point which RPs have to see. That's the NPA status, because so many things are involved in this. Suppose NPA 1 year criteria is there that it should the NPA, if suppose 1 month back it has become NPA, then you cannot, on the basis of this, you cannot deny. If any person, the account is NPA, but he makes the payment, then also you cannot deny it. These are all the provisions in the C 29AC. So, and of course, there are some the persons who have been convicted for any offense, punishable with imprisonment for 2 years or more. They also cannot apply as a resolution applicant. And the most contentious which we come across on the bench is that disqualified to act as a director under the Companies Act. Because many persons are declared as disqualified. And what happens that some of them, though, as per the Companies Act 2013, they should have been declared as disqualified, but this ROC website doesn't show, doesn't declare them as. So there comes a question. No, I have not been declared by ROC as a disqualified to be a disqualified to act as a director. So how can you deny me this opportunity? So that's a contentious issue, that whether we will go by the definition or by the declaration as disqualified to act as a director by ROC. So in many cases, this issue has come before us in Hyderabad bench, and we have taken a view that, okay, even if it is not declared by ROC as disqualified to act as a director, but as per Act, if he should have been declared, then we have taken a view, now you cannot. Because you are falling in that line, though, okay, there may be some sort of lagging on part of ROC. So we have taken a view that no, such persons cannot be, though they are not declared by ROC, but as per law, if it is crystal clear that yes, they should have been declared, then we are not allowed. So that was a most contentious issue was this. Then NPA date also, some of the particularly, and the date was also very important in this. What has happened that some of the persons, they are declared later on. As on the date of the resolution plan, when they submit, they are not in the category of disqualified directors, but during the process, maybe after few months, they are declared. Then in that case, what will happen? Few cases comes to us like that also. So we decided that, see, the law is very clear. As on the date of the submission of the resolution plan, means that application. So that is, we do not take into that even if it is declared after that, we have allowed them. So this was a issue, this was a very contentious issue. So mostly the contentions in 29A was only on 2 points. NPS, 3. NPS, disqualification or to become as a director as per the Companies Act. And number 3 is the guarantors. Guarantors also, some are very interesting issues which we came across so while adjudicating. In one of the case, I will just like to bring before you. See, the CD was a corporate debtor was a MSME unit, and the promoter submitted a resolution plan because, as you all know, they are this 29A is not applicable to them. So they submitted the resolution plan and he became the successful resolution applicant. After he became the successful resolution applicant and he paid the money, then the bankers, because he was a guarantor too, the bankers came out with Section 95 application. Then his contention was, see, I have already been declared, and since I have been, it's a contradiction between this, what is that, 340 or something, no, which was introduced to allow the MSME borrowers give
240.
240A, sir.
240, no?
240A.
240.
Yeah, 240. So it's a contradiction between 240A and this Section 29A. It cannot be allowed. Since I have been declared as successful resolution applicant there, how can they start Section 95 proceedings against me now? So, but in that case, though during my tenure it could not be decided, we were just thinking. But in my view, because now I can say I'm not on the bench. So, in my view, in fact, this Section 95 is a personal liability proceedings, and they cannot be correlated with the CIR, Corporate Insolvency Resolution Process. So they have, both of them, they have to go independently because this personal guarantee is secured through the personal assets. So I think both of them have to go separately. His contention, in my view, is not tenable, but he has filed an IA and all that it cannot go ahead. This is not maintainable. 95 is not maintainable against me. So that's how these are some of the contentions which come across in Section 29A. And in some of the cases, the other parties, the unsuccessful, particularly the unsuccessful resolution applicant who are at number 2 or number 3. So they file many IAs, giving that so and so and so. This SRA was attracting Section 29A because of this reason or because of that reason. But RP has not taken that into cognizance and has his plan was approved. So many such applications. So to avoid all these things, I think we have to be very a thorough sort of this background check and that is required by RP. And in fact, in Hyderabad, most of the RPs were really doing a wonderful job, and we have not come across many such cases where such problems were there, but only in few cases that this type of things were there. So now the only issue is that, okay, some of the very important judicial cases are there which really throw a light, particularly on this Section 29A. One of the cases in that series is that our Honorable Supreme Court of India has decided in ArcelorMittal India Private Limited versus Satish Kumar Gupta. Many of the issues pertaining to Section 29A were really clarified in that judgment. First of all, Section 29A was interpreted at length in this judgment. What are the stages of ineligibility? Then they came out with a wonderful thing that this corporate VL, one corporate, another corporate, there is a sort of corporate wheel. Means this subsidiary, then subsidiary of subsidiary, something like that. So any RP, he has to pierce that corporate wheel. He has to go. Generally, I used to prepare a chart. We have come across a few cases like that. Then we will prepare, okay, he is promoter of this, then this, then this, then this. So sometimes the chart goes up to 4 or 5 stages. And then we come to know that, oh, this man is related to this company as well. Through this, if we thoroughly analyze. Apparently, it is not. But if you analyze it thoroughly, if you pierce that corporate wheel, which they have created by promoting so many of subsidiary and then again subsidiary, second stage subsidiary company, third stage subsidiary company, like that. So that's a very important aspect which I think RPs are required to see, in particularly in the bigger accounts. And that is very well explained in this judgment. And then, of course, there is another judgment which came out in this. What is that? Where this challenge, this actually the just 1 minute. I have written somewhere. Yeah, it was Swiss Ribbons Private Limited versus Union of India. Basically, in this case, the constitutional validity of Section 29A was challenged. And then Honorable Supreme Court of India upheld the constitutional validity and giving very wonderful conclusion, particularly in the last paragraph. They have given so much of data that this much amount was recovered, this was done like this much amount was flown back into the industry. So this creditors in control system of this resolution of CD is wonderfully doing well, and there is we are not going to discontinue it, and it's fully valid. So they really upheld that this Section 29A, which is barring promoters and their related parties or the connected parties to come into the play through backdoor entries is very much valid. And so that's how this this was also a very important judgment which came out on the constitutional validity of section 29A. So these are some of the things which I wanted to just cover. And then, of course, for some of the suggestions to the IRPs, I think due diligence on applicants, whosoever are resolution applicants, is a must. That should be carried out in a very thorough manner. Okay, no undue person, no related person to the corporate debtor should come. We have to see the basic intention of the legislature is that these persons should not be allowed to take back control of the units which they themselves have destroyed. So when the intention is that, we have to follow it. Be RP or be as a adjudicator, everyone should follow that, and they should not be allowed. We should make all out efforts, and that's how this their mentality is now changing, and that's really creating a big ripple effect in the economy, big positive effect in the economy. So for this, for doing all sorts of due diligence, you should all sides of public database is there, RBI is there, MCA website is there, CIBIL is there. All those things should be at least collected, checked thoroughly, that nothing adverse is there about that person in those reports. Then that connected person, related parties, and this piercing the corporate wheel, all those things they have to see. Of course, disclosure requirements, all of you are taking in the format. So you have to keep it. And wherever you need, wherever you are not sure that whether it should go this way or that way, or whether we should take, it's better to take it to the COC. Or even if COC is not confused, come to the come to the bench, come to the NCLT to take a final view on that. It's better that before allowing them and then going back to square back to one position. So it has happened in few cases. Few cases it has happened. The whole plan was almost at the approval stage, and then all of a sudden, because this adjudicating authorities were given some proof that yes, it was wrongly done, then the whole plan was reverted back to the original position. So just to avoid such sort of unpleasant situations, it's better that if you need some sort of a small adjudication at the initial stage, take it, finish it, file a small IA and get that clarification. So these were some of the things I wanted to convey from my side. If I think I don't know whether this question answer or session is there or not, but otherwise, if you have any 5 minutes, we can take it. Yeah.
Sir, I'm Ashish Makhija. I think we are absolutely.
Yeah, Mr. Makhija, thank you very much.
No, I'm absolutely delighted that you are here. And I think we will not lose that opportunity. We will not let you go without questions. Don't worry, sir. I think we have got very proactive members, and I think they are very ready. In fact, I've got a one question now based on what you mentioned just now. You said that if you are not sure whether this case will go this way, 29A, or that way, so you come to COC and then you can come to the adjudicating authority before taking a final view. This is what I said.
Yeah.
Sir, you are right when you say, but at the end of the day, we have seen the vision of the benches in Delhi and other places also. I'm not saying that your view is contradicted to them, but all I'm saying is their view is that, look, this is not our job. This is your job first. So you do it and then don't come to us for clarification. So what is your take on that, sir? Is it a good approach to come to for clarification or not, sir? I mean, we are all confused.
See, even if, okay, I think some of the benches may not, but it's, I think, in the interest, not for each and every silly clarification you should go to the bench. But if it's a clarification which is greatly going to impact the whole resolution process, I think it's better to seek the clarification at the initial stage itself. And
Okay.
I think that you have to convince the banks that, sir, if this clarification is not given at this stage, it may spoil the whole process at the end. So it's better that if you clarify, though it's not your duty, okay, accept that. But still, we want that sort of guidance or something sort of this. We have given in few cases, I think one or two persons this came. So we say, okay, and you are right. We say that yes, it's not our job, but okay, you can go this way.
Okay. So I think this is possible. So friends, I think this is a big takeaway today, that if there is a huge doubt, not for the small doubts, we should not be
Yeah,
approaching
correctly.
NCLT. It's a big issue, I think you must approach for clarification. I think this is what our chief guest is saying. Friends, any more questions? I think we should.
Hey, Mr. Makeja, even if it doesn't come, you are
Right.
not going to lose anything
Anyway,
except
correct.
few days.
Correct. So even if I make an application, it is dismissed. So even then, my ground is ready that I went to you, sir.
Yes, correctly. Yes, correctly. Very right.
Friends, I think you can open your mics, you can unmute yourself, ask your question, please raise your hand. Let this opportunity not go waste, okay? So I think let's ask any question relating to 29A compliances. Of course, we have got one of the best lead speakers also after this, but you can still have an opportunity to ask any questions. Anyone would like to ask? Okay, I think, sir, your deliberation was so perfect that everyone is
No,
clear.
it's okay. Even if at a later stage also, if anybody
Right.
wants some sort of, I am here
Sir,
till the end.
may I ask something?
Yeah,
Sure,
Tina,
sure.
go ahead, Tina.
Sir, there is a case. Somebody is classified as a willful defaulter,
Right.
but the same order is being challenged.
Yeah,
And
it happens in many cases.
And further, there is an order of DRT that there is an NPA date was wrong. So now, as an RP, should we allow those people to participate because the order is being challenged and outcome is still not there?
See, first of all, this willful defaulter issue. If one person is declared as willful defaulter, okay, so until unless there is any stay, if he has challenged, that doesn't mean that he has come out of that category of willful defaulter. So that challenge is still, it fructify getting an stay order. It's of no purpose. It won't change any status of that person. He will continue to be a willful defaulter. Number one
Uh,
thing. Second, you asked about the date of NPA. Yeah, if it stays there, certainly, if it's by a higher, you have to abide by that. We have to abide by that. Okay, for that period, certainly the only option is that as soon as possible, let that stay be vacated or a final order be obtained from the appellate tribunal or the High Court. So that's the only way out. So now coming to the NPA. NPA status, actually, some of the date of default, NPA, these are some of the very confusing things I am seeing in most of the IPs as well as most of the advocates. What they do, they write the date of NPA as date of default. That's very much incorrect. In few of the cases, we have sent them back. We have asked a clarification that how it can be the same date. So you submit a right date of NPA. See, the date of NPA has to be earlier than the date of default has to be earlier than the date of NPA. It depends on the type of facility. If it's a cash credit facility, 90 days default. If it's a term loan sort of thing, then 6 months, something like that. There are so many type of advances. Depending on that, for how many days the default continues persistently. That is a very important thing. So I will just explain that also because it's very interesting. So persistently, if the default continues for 90 days, then only in cash credit account, then only it will become NPA. So if a bank have to, so what happens in some cases, though actually the account is means per se is NPA, but they avoid it. Like what they will do when the 90th day is coming, after 85 days or 86th day, they will put some money in the account. Bring that account below the drawing limit, sanction limit. Okay, for 1 day. Then again the next 90 days starts. So that's how for 1 year, 2 years, some of the accounts they avoid the tag of NPA. So that's a very typical thing, but of course we cannot do anything in that. So we have to accept the date of NPA as declared by the banks. That's a final because that's audited by the auditors also, and that's reflected in their balance sheet. Because all this sector classification goes to the final balance sheet as well. So we cannot do any chart with that date of NPA. Whatever is declared by banks, I think that we should accept.
Sir, one more thing I will add on. When they have challenged an order has come, it is common in MP. I am going through the similar orders in many cases. Like High Court orders ki no coercive action should be taken in this case of willful defaulter. Now, what
Right.
is a coercive action in
A coercive action you cannot take. See, it's not a coercive action. Not allowing him to be a resolution applicant is not a coercive action. You are not snatching any property from him. You are not putting him behind the bars. So nothing no coercion in that. Simply you are not allowing him an opportunity which he is seeking. That cannot be a coercion. So if the order is for coercing no coercive activity, that's not applicable in this case. But if it is very clear that the status of defaulter as put in by the bank, the tag of defaulter is put on hold, then the thing is out of control.
Thank you so much, sir.
Sir, thank you. Suhasini ji, now you can take over.
Thank you, sir. And now I request Ashish Makhija, sir, to present the memento to Charan Singh, sir, and also say few words about.
Okay, so sir, we are showing online. This is an online meeting, but we will send it to you physically later on. So
thank you very much. Thank you.
With deep appreciation, sir, we request you to please accept it. And sir, on behalf of
even I am also an this insolvency professional, but not started any practice or anything.
I know.
And you came in our training program as well.
Yes. I'm aware of that, sir. So I think it is truly my privilege as president of IPNet and also to deliver the vote of thanks. And we extend our deepest gratitude to you, sir, being a formal honorable member of NCLT, for sparing your time and joining us today as a chief guest. I think, sir, your address, I heard it in part because you see, I was in some other IIBF program was there. So I just, you see, it came from there. So I think your observations on legal interpretation, evolving jurisprudence, and the practical role of the IPs, I think were really thought-provoking and they were extremely, extremely relevant, sir. So thank you so much for being here, sir. And I think we will continue to see you in future also, sir. And since you stay very close by, I am also in Noida. So I think I see you sometime. Right. Thank you, sir. It's a pleasure to have you here, sir. Thank you.
Thank you.
So
I can log out?
Yes, sir. If you wish to stay, it's up to you, sir. Otherwise, you are free, sir.
Okay. Thank you very much.
Thank you, sir. Thank you, Ashish, sir, and thank you, Charan Singh, sir. Now, I request Geeta Sridhar ma'am to introduce the lead speaker. We have two lead speakers for this topic, Mr. Prakul Tadi and Mr. Lalit Mathur. So first, Geeta ma'am will introduce Mr. Prakul.
Good evening, all of you. It's my pleasure to introduce the first lead speaker, Mr. Prakul Tadi. He has built his career with the intersection of law, finance, and governance. He has brought in a unique blend of qualification and hands-on insolvency experience. He is a registered insolvency professional and partner at Prakul and Kunwar Preet LLP, a practicing company secretary firm. Over the years, PNK has built deep expertise in handling various critical aspects under the insolvency and bankruptcy code. Their work spans around the drafting of resolution plans for resolution applicants, review and compliance verification of plans for resolution professionals, and preparation of due diligence reports under Section 29A. PNK has also provided strategic and operational support services to insolvency professionals across India, assisting assignments before several NCLT benches. He started his professional journey with Nadco Pharma, where he worked in litigation secretarial functions. He later completed his graduate insolvency program, including a 9-month training with EY and a judicial internship under NCLT Chennai. He's handling, or together he has handled over 50 assignments under IBC as RP or liquidator or in the form of support services. Over to you, sir.
Thank you so much for the introduction, ma'am. Good evening. Good evening, everyone.
Good evening.
So, should I still stick to the 30-minute timeline, or should I make it much quicker considering the
30
extension?
minutes is fine. Yes.
Oh, okay. Thank you. Okay. So, I think a majority of the legality has already been captured by Sir, so I will not touch upon that. I've decided that I will only stick to one peculiar case which I was dealing with during one of my assignments on reviewing the reviewing the eligibility under Section 29A, rather reviewing whether they are ineligible under Section 29A. So one such peculiar case, I'd like to take it up and explain to the people like what exactly is the peculiarity which I saw in that particular case. Okay. So yes. So in that particular case, I was looking at the eligibility criteria of a PRA who happens, very clean in terms of her financial profile. There was nothing for us to point out, and we have seen that the company has got multi-layered shareholding from another corporate has more than 50% shareholding in the company, and there were indirect shareholdings in the next layer of the company. So all that we have done, like any other case, we have gone into the detailing of the shareholding patterns of various companies which has got interlinked shareholdings, and we could not find anything on the PRA. But interestingly, this PRA was not in good terms with her husband because they both have filed for a divorce petition. And the husband, who is currently, they are still not divorced, but the husband is actually a promoter of a company which is an NPA. Now, that has been a point of interest when we started digging into it, that as per the PRA, who has submitted a plan on her individual capacity, she says that she has absolutely no relationship with her husband and that she is independently submitting this plan. While we have an information solidly from the public documents that her husband is the promoter of a company which is a NPA. Now, that's when we had to dig deep into understanding how to draw a difference, or how to state that, how to conclude whether they are relatives or not. Because as per the IBC, the definition of relative includes even the husband, wife, right? It doesn't talk about a situation where they both have filed for a divorce or they're waiting for a partition, etc. Awaiting for that change of relationship from husband and wife. So that was one interesting point which I encountered during my experience going through the Section 29A plans. So that's when I started digging deep into this thing, and what we did initially was to understand firstly whether this gentleman who is the husband of the PRA, how can he be ineligible under 29A or not as a connected party. So we started looking into that. So then we realized that the husband who is the husband of the PRA, though he is disqualified under 29A per se, but he was a promoter of an MSME. So therefore, in the cases where he was a promoter and where there was NPA, in both the cases, the companies were MSMEs, and in both the cases, he was the resolution applicant. Now, see, again, it became more complicated because under Section 29A, MSME is, of course, read with Section 240A. Only under Clause C and H, we can draw some exception for promoters. For the companies which have NPS. So for MSMEs, Clause C and Clause H are not applicable, which is fine. But in this case, the company for which I'm doing 29A is not an MSME, but the connected party was a promoter of a company which is an NPA, which is also an MSME. Now, what difference does it make? If you just give me 1 minute, I'll try to highlight that on the screen. This is. Yeah. Okay. Right. See, what I was trying to highlight is I was looking at Clause J. Okay. So the PRA is completely qualified under 29A to I. So there is absolutely nothing on the PRA. That is the original applicant. She is completely qualified. But when I started looking at J, which says has a connected person not eligible under A to I. Now this is one element which we were trying to dig deep while we were doing our diligence to the RP. So our point was, yes, she has a connected person. Now, who is a connected person? So let's look into that. Connected person expression means, for the purpose of Section 29A, any person who is promoter or in the management or control of the RA. Now, RA is an individual in this case, so therefore this ideally will not apply. Second, any person who shall be the promoter or in the management or control of the business of the CD during implementation of the plan. So ideally, the PRA herself, or if she is engaging anybody else as a promoter of the company, if she does that in the resolution plan, then they will also come under this. But she said she will be the sole person and any other nominee. So ideally here also we don't see her husband or anybody else fitting in for an individual. Next, the holding company doesn't apply, subsidiary company doesn't apply, associate company doesn't apply because she is an individual, or a related party of a person referred to in clauses 1 and 2. So since she will be the promoter of this company, so her related party will also come under this is what was our initial observation. And then, of course, if we look into the definition of related party, because if it's individual, we have to look into 24A. And for an individual in relation to an individual, so related party in relation to an individual will include a person who is a relative of the individual. And the definition relative, I mean, the explanation of relative is husband and wife. So it's very clear that her husband falls directly under this definition of related party. But what brings us back to the discussion is the point that, okay, now she has a connected person, that is her husband. Now, whether that husband or the connected person is he eligible under A to I is what I am supposed to verify as an independent professional. That's why the RP has appointed me. So now when I started digging into this, okay, I started looking at it. Firstly, he is not an discharge insolvent, fine. He is not a willful defaulter. We checked the willful defaulter list and the provided by the RBI and all the online thing. We checked that CERSAI. We did what we can through the resources available, and he is not a willful defaulter. Now comes point number C. The point number C says there has, I mean, at the time of submission of the plan, has an account, okay, or an account of a CD under the management or control of such person, or of whom such person is a promoter. Now, at the time of submission, has an account of whom such person is a promoter is what is the relevant point for us. Whereas it is where it is classified as an NPA for a period at least not a period of 1 year, and not at least 1 year has not lapsed before commencement of CIRP. So now here what happened was he is squarely fitting into this. The reason being he is a promoter of, he has an account. It's not of the CD, but of any other company, which is fine. Now that company is currently undergoing CIRP. So technically, I mean, there are two companies. In one company, it is undergoing CIRP. it was undergoing CARP, he submitted a plan, he became a successful applicant, and he started implementing the plan. So technically that is out of picture because as on today, it's a standard asset. But there is one more company which is undergoing CARP where he is the resolution applicant and the plan is approved by the COC, yet to be approved by the NCLT. Or it's approved by the NCLT, it went to NCLAT and all. There are some litigation points on that also. We'll come to that. But in both the cases, both were NPS. Sorry, both were NPS and both were MSMEs. Now, what then the next step we tried to see was this person was not eligible under 29AC with respect to this company for which I am doing the 29A analysis. But he was very much eligible for those companies which turned into NPS because those two companies were MSMEs. Now the question before me was, if the connected person is eligible in the company for which there was an NPA, does that mean he will also be eligible under 29AC for the company for which we are doing the 29A analysis? Now this is one point of discussion. Yeah, Sachinji was saying something. Okay. So this was one point. Yeah, this was one point of discussion we had before concluding our report to opine on whether the NPA status of an account in which the connected person is a promoter will have an impact on the ineligibility of the PRA in this company for which is not an MSME, for which through section 240A protection is also not there. Now that we felt firstly that was an extremely interesting point to analyze on. Now, if you see, when you start looking at this, what is the idea behind making the connected person, making the PRA ineligible because of the ineligibility of the connected person is that if the law makes the connected person ineligible because this guy is connected to the other person, so technically or indirectly, even this PRA should be made ineligible. That's the whole idea. So we went on that idea wise, and also of course legally, that if this connected person is allowed to submit a allowed to submit a resolution plan in another matter by the NCLT, by the COC approving the plan. Therefore, when he is eligible under 240A or in the other two matters, and he had also submitted a plan in the other two matters, which is in the due process of law. So as long as he is eligible for submission a resolution plan in the other matters, his ineligibility in this case should not cause an effect on the PRA was our first impression. That, okay, the PRA who is submitting the plan in this case has a connected person and the connected person is eligible for submission of that plan because of an exemption available for the other two MSMEs. Therefore, that even though he has an account which is an NPA, still we could not point out the PRA to be ineligible because in the other matters, there was a 240A ineligibility provided on 29A, C and H. Therefore, we cannot concludingly say that the gentleman has an ineligibility under 29A, C. So that was one interesting thing which we came across during our analysis. The next part is with respect to the relationship between the two. Now see, the relationship between the two is such that they are at the verge of ending their relationship of husband and wife. But as per the IBC, there is no such discretion to not say that the other person is a related party. So that's when we had come across the NCLT order in that case. I'll just quickly show the extract of the order which we prepared. So this is extract of a report which we prepared. So in the NCLT, so what happened was in another matter where she submitted a resolution plan, things went beyond and it reached out to the NCLT. In the NCLT, the bench heard that if even though, see, first it says, since Mr. So-and-so was not barred from submitting a resolution plan of an MSME, his wife also cannot be barred from submitting a resolution plan with respect to the present CD. So this was a justification of our earlier stand for not making her ineligible under 29A-C. Even though this person per se on paper, if you see, he is ineligible, thereby she should also be held ineligible. But we could not hold him ineligible because the basis on which we are saying he is ineligible, in those companies he submitted a plan and he was allowed to submit a plan. So similar interpretation we can see in the NCLT order saying that where he was not barred in the company which turned into NPA, she should not be barred for that reason for submitting a plan in the current case. That is point number one. Then NCLT Mumbai goes on to say that this is an extremely important point. It says the bench is aware that for attaching any disqualification under 29A, it is imperative to establish connection with the business activity of the RA. Now, there is no mention of this in the section 29A or in the definition of section 5, subsection 24 or 24A. So the definition of related parties nor ineligibility under 29A have any mention about the relationship or connection with respect to business activity of the RA. It simply says connection, connected party. It doesn't go ahead. It just simply says connected party means a related party. A related party means a relative. So that's how it's a simpliciter section. But of course, this NCLT Mumbai ruling kind of gives an indication in which we have to establish this definition of connected party. It says it is imperative. So you have to look into the connect. You have to establish a connection with business activity of the RA. Rajesh ji, you're saying something? Okay. So you have to establish the connection with the business activity of the RA, and that's something first we have to check. Then she says, sorry. Then it goes on to, she goes on to say, sorry, the bench goes on to say that in the company in which her husband is operating, she has hardly any shares, which is a fact. We have verified the shareholding. She has hardly any shares in that company, probably like very less percentage on her individual name. So where the bench goes on to say that of a company without actually any connection with the business management and control of the company, she cannot face disqualification under 29A. Then they go on to link this from the definition, from the ruling of Swiss Ribbons. So Swiss Ribbons, as our sir has also rightly pointed, Swiss Ribbons has touched upon various aspects of the CIRP process, including the scope on 29A. So where this is the extract of the ruling from Swiss Ribbon, where it very clearly says, in absence of showing that such person was connected with the business of activity of RA, such person could not possibly be disqualified under section 29A(j). So the very inception of this business interpretation on business activity comes from the Swiss Ribbons ruling. So though section 29A is silent on it, when we talk about connected person, we should always look at linking it with the business of activity of the RA. So which ideally means the PRA should have some level of connection, and we have to establish that there is some level of connection with respect to the business activity of that connected person. Merely because they are husband and wife, or merely because they have the blood relationship and relative definition under 524A, we should not, beyond a doubt, we should not stop digging into establishing this fact that they should have a business activity. If we don't establish that they have business activity, they can very much defend their case against the RP. So therefore, we should try to make efforts to see if there is any level of business relationship. Then how do we do that? We, as RPs, we have only limited role. One, we should see whether they have directorship. Second, we should see whether they have shareholding. So if we feel there are directorship as well as shareholding, or more than 50% or 40% or 30%, 25%, 20%, depending upon the percentage of shareholding, we should try to give an opinion that, or maybe to establish if whether or not they have that business connectivity between the two. Otherwise, we cannot disqualify one PRA based on the ineligibility of the connected person until and unless we establish the connection with the business of activity of the RA. And that's what even the Swiss Ribbons highlights in its ruling. The Honorable Apex Court highlights with respect to Swiss Ribbon in this ruling. And if you see the other part of it, the other part of this extract, it also says all categories in 29A(j) dealt with persons, natural as well as artificial, who were connected with business activity of the related resolution applicant. Because see, section 29A(j) per se does not contain any specific provision. It only says as a connected person. It doesn't talk about business activity anywhere. It just even when it is explaining the purpose of this, who is a connected person, it doesn't even mention the term business activity. It is it's the Supreme Court ruling in Swiss Ribbon which mentions this with respect to a related party, wherein it says that they should be connected with the business activity. So the connected means connected with the business activity of the RA. So until and unless they are connected, they are connected with the business activity, merely because they meet the definition of related party, we should not hold them as ineligible. That is point one. Then it also says that the expressions related party as well as relative must be read non-sitter or solid sources with categories of persons mentioned in explanation 1, and so read would include only persons who were connected with business activity of resolution applicant. So that's where they conclude saying that when you look at the definition of related party or relative, ultimately they should be connected with business activity of the resolution applicant. So this was the extremely important point which I felt that it's an extreme need for us to not simply tag them merely because they are husband and wife. We should not simply tag them as related until and unless we can prove this. So this was one particular case where I was able to experience this based on the facts of the case. And particularly in this case, since they already filed for a divorce and all, they were able to show that beyond a reasonable doubt that they do not actually continue any connection even otherwise also. Then subsequently, of course, there was one more case where in SS Naturals where NCLAT had also ruled, even that was referred by the NCLT. And finally, NCLT has held that there is no ground of disqualification because they have no business relationship or concerns in her husband's ventures, and therefore she cannot be treated as disqualified. Now, this order and the interpretation and these extracts which we were able to get it from the honorable from the court from the cases of Swiss Ribbon as well as SS Natural Resources, this has given us a direction that okay, when we are looking at analysis, even though it's plain and clear her husband is ineligible, okay, but we got a direction in this from these orders to look at whether there is a business connectivity, business activity. So when we say connected persons, there has to be a connection with the business activity of the RA. So this is one thing I wanted to discuss during this session. Otherwise, all other 29. Yeah. So all other 29A provisions are based upon, of course, we had to take some subscriptions to get the access of certain resources. So to see to it that for each, suppose there is a company which is a PRA, then the company has got, in one of our cases where we were analyzing, we got 10 directors in that company. So for each of the director, we had to do this eligibility check to see that the company as well as the directors are not ineligible to submit the plan. Then there was one interesting case, apart from what I was talking about. Similarly, again, on basically, I just wanted to focus on this connected person in this session today. So in that case, what happened was the PRA is a stressed asset fund. It got recently incorporated, and it is a AIF alternate investment fund registered with SEBI. Now they submitted a plan and EOI, and we were asked to check their eligibility. Even before the plan submission, they first wanted to understand whether they're eligible. The reason why there was a hunch by the RP is that they have submitted a profile. In the profile, they said the co-founder of this fund is someone who is the CFO of a company, right? So we started looking into the company where he was a CFO. That company is undergoing CIRP. And he was a director of that company when the company was NPA. So it is very clear that under his management as a CFO, as a KMP, as well as a director, there is a company which has gone, which was declared as an NPA and which is currently undergoing CIRP. Now, that being the case, 100% the gentleman is ineligible. Now, this PRA is claiming this gentleman as the co-founder. So then we had to dig into this. And what we started doing was, since it's an AIF, they had a trust, and it's an LLP, which is the investment manager. So we started looking into the profiles of the partners. That's when we have seen that even though this gentleman was shown as a co-founder on the website of the company, he is not holding any shares in any of the LLP, or he is not, nor he is a director or partner of any of these entities. So that's the first relief for us to see to it. And second thing is, an interesting thing again is that it is a SEBI registered AIF. So technically, as a SEBI registered AIF itself is a big relief for us because generally they are funds. Okay? They are funds who are registered with a financial entity. So technically, for them, this should not. I mean, because they are a fund registered with SEBI, at least the profile wise, there is already a good amount of check done by the SEBI before allowing for any such registration, right? So therefore, based on that, we came to a conclusion that, okay, they are eligible under 29A, but we immediately informed the PRA that, disclosing the details of a person who is a promoter or in charge of a company which is undergoing CIRP on your website will have repercussions in terms of eligibility, because even though there is no essential control which we can establish through the documentation, but still such kind of disclosures might have a problem. So we have indicated that to them. But ultimately, my point from this discussion is that we need to look into the legal documentation thoroughly, and based on our hunch or based on an allegation, we should not try to make anyone ineligible. So as a RP, we need to have solid backing in terms of documentation, solid backing in terms of due diligence before we can conclude whether a PRA is eligible or ineligible. At times, because of small points, we very simple. It might sound simple after we conclude, but at times when we do the diligence, there will be some hiccups for us on interpreting certain nuances, which usually tends to take some time. That's why we take a good amount of time before we give an opinion to the RP. A good amount in the sense we take at least a minimum of 7 days time to come out with a due diligence report based on the number of PRAs based and also the levels. Like if the PRA is a subsidiary of a company which is a subsidiary of another company, and if they have multi-layered investments and too many directors on board, is a listed entity and all, then the level of digging becomes more and more, because ultimately that will help the RP tomorrow if at all any kind of investigation or any kind of inspection comes on the RP in analyzing the PRA. Then all this backup will help the RP in establishing what level of efforts have been put to do the due diligence of the PRA. So just two takeaways I would like to inform during my session before I conclude. One, when we look into the definition of a connected person, we are not looking at the simpliciter definition under related party or related person or relative. We are looking at a connection on a business activity level. So only when there is a connection with respect to business activity of the PRA, we should term the other person as a connected person. Otherwise, they will not come under the definition of connected person. This we learn from the Swiss ribbons, also from the order which I was referring to a while ago in the part of my presentation. Second, with respect to profiling. So even though there is a website disclosure or some news article which mentions the name of somebody who is in charge of this company, etc., etc. But as on the date the plan is submitted, if the documentation with respect to the firm is clear, if there is no shareholding or directorship of anybody, then we cannot per se disqualify them. The reason being, all the documents with respect to the constitution of it clearly justify that the other person is eligible. So these are the two points I wanted to highlight during my session. And just before I conclude, we in the point number D, 29A-D, where we are talking about convicted for any offense punishable with imprisonment. So it's very clear that there has to be a conviction. Mere imprisonment will not make anybody ineligible. So this is also one misconception. So just because somebody is in jail or under custody, that should not have an impact. As long as they are under trial, there should not be a problem. But if they are convicted for any offense punishable with imprisonment, only then this clause becomes applicable. And furthermore, there is one clause related to the reason why I had to take this out is with respect to the third point I wanted to highlight during the presentation. With this, we can conclude, is this clause I. So this is also one of the clauses which we usually don't come across, wherein it talks about so-and-so is subject to disability under any law in a jurisdiction outside India. Now, this becomes much more interesting because firstly, knowing the provisions of law in another country itself is quite a difficult task for us. So suppose we should first know whether the other person is a director of a foreign company or had he been ever arrested in a foreign territory. So these are quite difficult things to track. So that's when we should have to do some a search on news media level, and also try to gather more information from any available sources to see whether they have any foreign presence in terms of their business. And if they have a foreign presence, and by any chance if there is some level of difficulty, we should always try to tackle. Usually this we have to see for promoters, because promoters are immune generally, because if the CD is an MSME, they are immune from ineligibility under clause C, which is NPA thing, and clause H, which is the guarantee thing. But they are not immune under I. So if there is a promoter who is submitting a plan in India, but he is actually arrested for an offense in any other territory, then we should dig into an understanding what is the level of that offense and what additional documentation we need for that. So in one of our cases, we referred our known contacts based out of the US, because the promoter was actually arrested in a territory in the US, in one of the states, and we took an opinion from a local lawyer to ascertain that it was actually not a convicted. It was not actually convicted. It is only a process of investigation. So this is the point number 3. So connected persons, we need to look at the business activity. Second, mere disclosure or our news articles cannot disqualify somebody. We should look at the legal documentation like shareholding, etc. And point number 3, any of this disability in a territory outside India, even that will attract. So for promoters, particularly where we are, even though it is an MSME, if the promoter is ineligible under I, or for that fact any other provisions, if not in India, even in a territory other than India, then we will have to hold them liable. And if you see, it doesn't give any immunity from I, meaning that if the promoter is ineligible for an NPA of a company which is outside India, even then they are ineligible in under 29. So these 3 things I thought would be a good thing to share in this afternoon's time. So with this, I conclude. Thank you so much for the opportunity, Swasti ma'am. Thanks a lot.
Thank you, Prakul. Thank you very much for sharing the dynamic aspects of Section 29A. So, for the foreign jurisdiction also you have highlighted. This is something
Yes,
new. And there is one query in the chat box we would like to ask you. This is regarding Section 29AE. Will DIN suspension under Section 164(2)(b) due to non-submission of financial data to MCA makes director ineligible?
Yes. So there is one criteria with respect to ineligibility is disqualified. It doesn't talk about any relevant. So a disqualification can be on several reasons under 164, but it talks about disqualified to act as a director under Companies Act. It does not comment on anything beyond that. But only relief it gives is provided that this clause shall not apply in relation to a connected person. So which essentially means if the connected person is disqualified, it will not affect you. So as long as you are qualified to submit, you can submit the plan. So usually this applies only for individuals, not for corporates. But for a company also, if the director of the company is disqualified, then what? That is also a question. So therefore, we have to be careful about it. But irrespective of the ground, be it for non-submission of financial statements or any of the ground, the clause is silent on it. They will still be disqualified to submit a plan. They will be ineligible technically. If it is something we can resolve by submitting the plan or something, that is also an open-ended question. But yeah, as per your question is concerned, they'll continue to be disqualified, and they continue to be ineligible under 29.
So in Reliance, Anil Ambani was not considered as a related party to Mukesh Ambani.
Yeah. That's because they have established that there is no business activity.
Okay. And regarding this foreign territory you are mentioning, whether the MSME promoter also this is applicable?
Yeah. It is because for MSME, ma'am, under 240A, if you see, sorry, I'll just show 240. Under 240A, it only says that the provisions of clauses C and H of 29A shall not apply to RA. So it beat for anyone. It is not just for promoter, honestly. It's for any RA in respect of CARP of any
Okay.
MSME, CARP or pre-pack. So the only clauses it is giving immunity from is C and H. So
Okay.
generally, we should not have an impression also that it is a general immunity and for all the 29A per se. It is only for C and H, which means we should still do the digging on whether they are ineligible under other clauses. So particularly if they have a foreign exposure and it is typical that they take loans, ECBs, external commercial borrowings, and they default even the ECBs. And particularly in foreign laws, they first want to arrest that fellow because if he travels, they won't be able to do any trial with him. So such things such things happen. So we should also find a difference that even though conviction is different from a mere custody or doing investigation, etc., by arresting them. So that difference we should know. And because it's a foreign territory, it is preferable to take an opinion from a local advocate or an attorney from that particular country so that it will give better backup for the RP.
So there are two more questions.
Okay.
Sir, Bhupinder Sethi, sir, can you unmute and ask the question?
Sir, this is regarding section 29E clause. If basically a director of the CD wants to submit the plan and his dean was suspended under section 164(2)(b).
Yeah.
Suspension is for 5 years, no, I think.
Correct.
164(2)(b).
After 5 years.
So that period is already expired 3 years back.
Yeah.
That is what I am asking.
Yeah, but then you have to renew. You have to make your DIN active on MCA by making that payment of 5,000 rupees and filing that DAR 3 KYC. You have to make your DIN active. Then you will. Otherwise, I mean, it's a technicality, but that is suggested. After 5 years, you are disqualified. If you don't do that, it might still have a reflection on the MCA portal. So better to file immediately for the DAR 3 KYC so that you will be eligible. And otherwise, also you can at least observe, give that observation to him. But as you are absolutely right, as per Companies Act, after 5 years, that disqualification will be deemed to be gone. So you will be, you can continue to operate as a director. But as per the current regime of IBC, of Companies Act, a director DIN has to be active to be considered as a qualified director, particularly after disqualification. So that is one procedural thing they can do to avoid any unnecessary misinterpretations. But you're absolutely right. So once 5 years is done, that is under Companies. You are absolutely right on the reading it alongside the Companies Act. So they will not be considered as disqualified after expiry of 5 years.
We have one more query. Srinivas, sir.
Can first promoter resolution plan?
Can first promoter resolution plan be accepted if no other plan is coming 3 times? There are 2 queries actually in this. Sir has posted. Sir, can you unmute and ask the question, sir?
Yeah, Srinivas, sir, go ahead, sir.
Public announcement is given.
Okay, sir.
Asking tenders, but no plan has come. Can original promoter plan be accepted in RP?
But they are otherwise eligible under 29A, sir.
Otherwise eligible, sir.
If they are eligible, then nothing wrong, sir. In fact, in the first round itself, we can go ahead if the COC is considering. So ideally, there is no such bar that promoter has to be given the last preference. As long as they are eligible under 29A, they are as good as any other resolution applicant. We can definitely put their plan forward.
Thank you, sir.
And the other point, sir, it's interesting. Can you explain that, sir? Wholly owned subsidiary.
Suppose the Indian company is having wholly owned subsidiary in Singapore, sir.
Okay.
It has established 5 step-down company subsidiaries in 5 countries.
Okay.
Can all the accounts of financials of those subsidiaries also to be incorporated in Indian accounts, sir? Holding company?
Acha. Okay, you're talking about consolidation.
29A. This is different questions.
Yeah, that's okay. But consolidation part, interesting, sir. So generally, when we look at consolidation, sir, we are only looking at one level consolidation, which is the subsidiary, only one subsidiary. But If all these 5 step-down subsidiaries are also holding like completely wholly owned by the subsidiary of us, then technically they also become the subsidiaries of this holding, the main holding company. So we need to consolidate for all the 6 subsidiaries, sir.
Sir, our main legislation says we holding company cannot have more than 2 step-down subsidiaries.
Yeah. But it will not apply for foreign companies, sir. You're talking about Companies Act only, that 2-layered investments. We cannot have layers more than 2. I mean, that's basically 2 layers, sir. One layer is one subsidiary, then the sub-subsidiary. But if these subsidiaries are incorporated outside India, that rule will not apply. It will only apply for companies incorporated in India.
Okay, sir. Okay.
Yeah.
So that's why they have incorporated.
Yeah. Usually that's why they do that. They go to Mauritius, Singapore, and all. They incorporate the companies and operate from there. I mean, they maintain the books there. Technically, the businesses are run here or there, depending. But correct, sir. So the layering thing is only for companies incorporated in India.
Okay. Thank you, sir.
Thank you. Yes, ma'am. I think there are no other questions in the chat box.
Rosni ma'am, are you there? So probably she has, due to some technical problem, she has logged out. She will be logging in soon. Moving forward, now I invite Geeta Sridhar ma'am to please introduce our next lead speaker.
Sorry,
and I request meanwhile, Prakulji, please stay with us for some more time so that we can have more questions at the end of the
his presentation. Thank you. And now I invite Pavitra Vyas, the insolvent IP, to introduce the another lead speaker, Mr. Lalit Mathur.
Thank you, Suhasini. Good evening, everyone. Mr. Lalit Mathur is a leading corporate lawyer and founding partner of Inco and Legal, a leading full-service law firm. He has 24 years of experience in litigation, commercial and corporate law, mergers and acquisitions, joint ventures, corporate investigations, due diligence, IP and commercial contracts, especially when it comes to international clients. Mr. Mathur is a nominee board member as well, independent director of various Indian and international companies, supervising their Indian and international business operation and taking active part in planning future business strategies. Mr. Mathur has led cross-border transactions across jurisdictions in France, US, UK, Japan, China, Germany, Italy, Spain, Argentina, Jordan, UAE, Malaysia, Australia, Singapore, and Hong Kong. Apart from ongoing law practice, Mr. Mathur is also an investor in tech startups in the field of telematic, data security, insurance, and education. One of his ventures, DCyrus, is working in the field of technology, including AI. DCyrus has developed various software applications for corporates, financial institutions, and professionals. The core product is Virtual Data Room, a secure file sharing application and document analysis using AI. DCyrus works closely with bankruptcy ecosystem in India, and insolvency professionals use DCyrus e-voting and claim management portal for creditors, voting and claim management online. His idea is to disrupt legal industry by using power of AI to reduce number of repeated actions performed by lawyers and other professionals on daily basis, and use AI to analyze the data faster with accuracy so that professionals can spend their time in taking decisions. He wants to use his domain knowledge in legal core domain, including investigations and due diligence of companies. Over to you, sir.
Thanks, Pavitra ji. Thanks for the invitation. I hope I'm audible. So I had a hard stop. I was thinking of finishing at 5:30. So Suhasini ji, but it just spread over, which is okay. I mean, I think there are a lot of knowledge shared by Charan sir and Prakulji on 29A. I would just repeat what Charan sir has said, that the main idea of 29A since its inception is that we have to find that black sheep, the promoters or the directors who were running the company and who have made that company bankrupt or insolvent. They should not take control of that company by from the back door or anywhere else. So I just share my screen quickly, and then I think I'll will not hold everybody from their weekend. So just let me know when my screen is visible, madam.
Yeah, it's visible, sir.
Okay, thank you very much. So I think as I mentioned that I was just making it light for everybody. So section 29A, as Charan sir said, that it is a section wherein we have to prevent the promoter to re-enter into the company. So my version is that we have to find that black sheep who wants to re-enter into the company. How is the nature of section 29A? I think Charan sir and Prakulji has deliberated that all the sections and subsection on 29A. I will not touch on that, although I have written, but I will be quick on essay. So it's negative in nature, as we already know. It's talk about defaulters, talk about defaulting promoters, connected parties, and all that. It's restrictive. It just restricts the access of the resolution process to ensure that those responsible for a company's failure do not again regain control. That's what Mr. Charan was saying. It is qualifactory, wherein it disqualifies certain persons and entities from participating in the bidding process. The law is well laid on that, and it is preventing and protective. So this is what the nature of section 29A is. This I don't think so we have to discuss on, because it's we have discussed on this. We have related party. I think it's a super exhaustive regulation wherein 524 and 524A give lot of information about the related party, and then of course section 2 of 76 of Companies Act also talk about that. Latest judicial precedent, I just want to touch upon that. I think there is one judgment which has made everybody sleepless, is the recent one which passed on May 2nd, 2025. It's about Kalyani Transco versus Bhushan Steel. If you read that judgment, there was a non-disclosure by JSW of a JV which they have signed with BSPL. I think there's a gross negligence which has been done by JSW, and which made them a related party. And I think Supreme Court was laid the law that even though CIRP, which is almost 8-9 years old, can be reverted. There is another judgment which I would love to mention here, and I would love that all the IPs and RPs should read this judgment. This is Honorable NCLT New Delhi judgment, 9th January 2025. We talk about IDBI Bank Limited versus Amzen Transportation Industries. The whole judgment talk about how a 29A report is given by two consultants, that too on the same day, to COC, and the judgment talks about that there was no opportunity given to the PRA to defend themselves. I think this is a judgment which I want to mention here, apart from the judgment which Charan said talk about ArcelorMittal and Swiss Ribbons. Going forward, I think so we also provide, as Madam said, that we provide various solutions, but as a lawyer, as a law firm, we also provide Section 29A report. And I think I was listening to Prakul when he was talking about a proper due diligence, and it's a time-consuming process, and it's a process wherein a lot of data has to be gathered from public domain, from the RPs, which I completely resonate with Prakul, because this is what is our struggle also. So how we implement 29A report process. So what we do, in fact, I would take the second slide first. So what challenges we face when we make a 29A report, and this is something which has to be resonate with whoever is entering into this 29A report business. Be the RP, be the IPs, or whoever it is, right? Be the lawyers or the consultants out there. So the biggest challenge we face, and everybody face today, is that there is no single platform to access the information. So we have to depend on MCA, we have to depend on courts, we have to depend on SEBI, CIBIL, and there are a hell lot of information resources available in public domain, which we have to find out our way through, right? And the process becomes much more difficult when it comes to individual, because there is not enough data available in public domain about individual, whether he is the guarantor or whether he is a PRA in some of the resolution plans, but it's so difficult to get those individuals data, for example their PAN, their Aadhaar, their DIN. And when we do such type of investigation, for example, take an example of anybody. Take an example of Rahul Shankar. For example, if Rahul is a name we have to find out. I mean, there are thousands and thousands of Rahul available in public domain. How can I find out this is the Rahul who is connected, or this is the Rahul who is the one who has cases against him, or he's done a fraud, or he is a willful defaulter? That's the biggest challenge which we face today. But we try to find our way out from them. Second, it's a time-consuming process because things are done manually, right? The challenges which we face, and it's a real challenge which I see my team struggling, is that we receive a call from an RP and they want a 29A report tomorrow, right? Actually, they wanted it day before yesterday, but now since they call today, they want it tomorrow, right? So the biggest challenge which we face is that since it's a time-consuming process and it leads to a lot of due diligence and investigation, it needs time for the team to research, to investigate, and then give the report, right? It has to be done case by case, code by code. When we prepare a due diligence report, as I mentioned in my first point, that there is no single platform to see. We see a court. We see a court in Mumbai. We see a court in Bangalore. We see a court in Himachal Pradesh. Wherever this PRA has done business with, just to find out whether is there any case pending and what type of case which is pending against them. So this takes a lot of time of our team. The same is with checking their CIBIL. So we have a dedicated team who just checks CIBIL of these PRAs, just to find out what exactly their CIBIL score is and whether they are defaulters or not. Second, last point, but not the least, what we have seen today in the market, that there are a lot of companies who are just providing reports generated through a software. I mean, how can somebody generate a report of 29A through a software? It's a highest risk I see for RPs, because those reports I have seen myself, they are non-conclusive. They are just putting all the blame on RPs, because they just give you an indicator, but they are not conclusive or signed reports. So for example, if tomorrow the resolution plan is being challenged, there has to be somebody who can stand in the witness box and depose in front of the adjudicating authority that yes, I have signed that report, and this is the process which I have used, right? So this is something which I want to highlight before this forum. Now, what is the process of preparing a 29A report? So what I do with my team, we find three levels of connected and parties of PRAs. Then what we do when we find that parties, we investigate, we find out the eligibility under Section 29A, and we investigate deep into it. Then this is a very, step 3 is a very important part. We send queries, right? We send queries to RPs related to red flag items, right? This is very important. Imagine you have 5, 10 PRAs. Those queries goes into various numbers. So you send those queries to the PRAs, and the most time-consuming process which we have seen is getting replies to those queries, because you send a query to RP, and then RP has to forward that. Every time you receive a query, either the query is answered half, or it is not answered the way you wanted it, because which means would give us some sort of indication that there's some rat to be smelled there, right? There is something which is hidden. So this sending queries make our report a part of it. For example, if tomorrow a report is challenged, and as an RP, you can always say that these are the queries which we have sent, but we have got these answers, right? So that queries form a part of our report. And after that, a full and final report is being prepared. I think the challenge, which, as I mentioned in my slide, the most biggest challenge which I see is that since there is no single platform where you can get or access all the data, so that's why what one hand is doing, the second hand doesn't know about it, right? And this is the gray area wherein all those PRAs who wants to, or as Charan sir said, all those promoters or directors who wants to re-enter into their company are taking benefit out of it. So thanks. This is what I just want to mention over here. I have my partner Rahul also in the chat, who can also take some answers if there are. I just close this down. That's it.
So any queries from participants to Lalit sir?
And I am available. I can send my email ID, madam. If anybody has any queries or any questions, they are free to send me an email, and we'll get back to them.
So there is one query in the chat box which says, it is from Mr. Bhupender Sethi. If it is not already taken, please reply.
It is all, sir, all the queries we have taken, sir.
Okay, fine.
So if there are no queries.
I'm Ramesh here from Hyderabad.
Yes, sir. Good evening, sir.
Good evening. Recent handing over of liquidation auction process to BankNet portal by the IBBI with effect from 1st April. The liquidator is not in control of any of the processes till the auction is announced. So after the auction, as per the recent liquidation regulations, I think regulation 12 of schedule 1, you are given only 3 days time for doing due diligence. So prima facie, the 29A is the first responsibility of the applicant. You may be a resolution applicant or a bidder in a liquidation. So in such a situation, we have to relook at our approach to the 29A. This is my observation. I mean, that's the problem. I think we have to solve it. If we have to go for a detailed 29A verification, 3 days due diligence is only time that's given to the liquidator for concluding the eligibility. And while that may be so, there will be pressure from all concerned. Once a successful bidder in the auction is announced by the BankNet portal of through IBBI, even the SEC will put pressure on the on the liquidator to conclude very quickly. So how do we handle this? And so in this, I slightly differ with, not differ. I want to request Mr. Mathur whether liquidator is really supposed to go into the depth, or the affidavit which is signed by the prospective resolution applicant or the bidder is binding. For example, you have quoted now the Bhushan Steel. The Supreme Court has questioned Bhushan Steel, not RP, on the non-disclosure.
Yeah.
So the prima facie affidavit should help us. Otherwise, in 3 days is impossible. And now the idea of IBBA also is not to do. Earlier, we used to do 29 verification of all the applicants, time-wise or money-wise or whatever. Now you are expected to do only the successful bidder at H1 and at the most H2, because you have an option to go to the H2 bidder. So in such a situation, whatever detailed verification, like experts like you will also not have time. Liquidator will not have time. I am talking about liquidation. So
yeah, Sir, yes. First of all, I completely resonate with the problem which you are talking about, right? Because this is the only challenge. It's not about the process, it's not about the law, it's not the only challenge which we face is the time, the pressure of the time, right? But in liquidation, first of all, let me talk about the first part of that if somebody is giving an affidavit, as per law, an affidavit is something which he is deposing under law, right? So I mean, if somebody is not disclosing anything, he can even go to the jail, right? This is law. I mean, he's committing a fraud by not disclosing something which he should disclose, because affidavit is something which is the fact of the truth, right? That is one. Second, when it comes to the 3 days time of checking it, so we have developed a system which we call I won't say it's a quick it's a quick report, but we can give you some sort of indicator because we are doing it for almost 5 years now. But if something can come up, I mean, we can revert to you, because we have a team of like 25 people working here. Because it has to be manual, right? It has to be manual. It has to be, you have to check a lot of parameters. You have to check a lot of, it's an ocean of data available in the public domain. So we have come out with a system wherein we can generate some sort of thing in it. It will not be a full 29A report, but it will give you some sort of indication that this is what is happening in this PRA, and these are the idea. I won't say it's a full report, but I will say it's a sort of executive summary of that report, and then you can take up with the whoever the H1 or H2 is, that this is what we have find out, and you have written in the affidavit like this. So this is something for you to defend in front of that whoever the H1 or H2 is. But yes, 3 days time is a very less time. It's very less time for somebody to do an investigation, and it becomes more difficult when the party is big, when there are thousands of connected parties to it.
Ramesh sir, if I may add, if you don't mind, this
Yes.
is Prakul sir. Sir, I like if we go through the regulation which you were referring to, though it says within 3 days of declaring the highest bidder, the liquidator shall conduct due diligence and verify the eligibility. It follows by saying that it should present the results, details of highest bidder and the due diligence to the SEC. So when there is no timeline for presenting it to the SEC per se, but let us assume on the 3rd day we presented it to the SEC. Now, in my opinion, as Mathur sir rightly pointed out, if we have an indication that it needs a detailed diligence to be done, or if we find a hunch that, sir, we feel prima facie it looks fine, but we may still need more diligence, I feel in consultation with the committee, we can still buy some more time to conclude the report and then only to declare the successful bidder. Because within 3 days, I do the diligence, definitely, but I can do a basic due diligence. And then if I'm convinced that there is no need for example, it's an AIF, like it's already regulated by SEBI, or it's a public sector undertaking where government is owning. So these things, we can say that, okay, I think the prima facie diligence is sufficient. But where we find some hunch, like let's say a promoter is submitting on the ground that there is no NPA, but we are doubtful that something else might be there. So I think within 3 days, we will still do the diligence, and on other eligibility criteria, if at all fixed, let's say we fix a net worth criteria, we do this also, then tell the SEC that we may need some more time. And for declaring the successful bidder, there is no timeline given under 12C.
So probably, I feel, I'm just playing around the language, sir. So maybe we can take use of that within 3 days conclude, have a basic idea, basic opinion formed through the consultants or through our own as a liquidator, present it to the SEC. If SEC says, no, there is no need to dig into this, declare as a successful bidder, still we can deviate from their advice or we can go ahead with their advice. That is up to us. So I feel that somehow we can try to manage at that state, sir. But otherwise, within 3 days, yeah. This is my opinion, sir. Ramesh, sir, you can give your views on that.
So, Prakul, as you are a liquidator of close to some 30 companies, I believe. So, how have you dealt the similar situation? What Ramesh sir is?
Luckily, I did it before the amendments. I closed everything before amendments, so nothing came up. But this amendment is actually.
No, what I want to conclude, like Lalit Mathurji is a lawyer. I am not a lawyer. If we can agree or you wish to advise us, the expectation from a resolution applicant or the liquidator is only prima facie verification. Is it correct? Is it correct? That's the point. Once a prima facie verification is done by the liquidator or the RP, you are legally, I mean, your job is done. Is that correct? That is the logic.
Ideally, I feel we have to be guarded like that, but unfortunately, the judiciary is looking at it very differently.
Yes.
Quite surprisingly, in the JSW
former
order.
member here, Hyderabad, Charan Singh Saab, is he there or is not there?
He is not there.
I think he left.
We could have, sorry, I joined late. So, okay. So, this is the point, sir. If you have to do it, the intention of IBBA is that you do it prima facie.
Yes, correct.
That is the point. So, tomorrow, if something comes up, this way, Mr. Lalit, or you can close the matter. I will not talk further. If prima facie, if the RP is done his job, is it correct? That's all.
Yeah, that's true. That's true. I mean, prima facie, the RP is not a Superman, sir. RP is not a Superman, right? He's he has to. He's running the business. He's doing the auction. He's running the whole company. I mean, what do you expect from an RP? Yes, it is. I agree with you.
Practically, I've seen about a couple of years back in Hyderabad, large insolvency assignments. At that time, no one knew 29A. So BDO, I mean, I don't want to name, some large companies have charged 30 lakhs, 40 lakhs, 50 lakhs for 29A. Later on. So that is what the problem.
Sir, I'm sorry, I'm cutting you. And as we are running out of time, Mr. Srinivas Mata has raised his hand. Mr. Mata, please. You can ask your question. This is the last question that we will be taking.
Yeah, please. I have a hard stop at 5:30.
Sir, regarding BankNet, liquidator has to give all details of the assets as well as liabilities, sir. That quotation which parties are giving is for taking all the assets with including the liabilities, sir.
Prakul, can you take this question?
Yeah, but I mean, generally we put only the assets on auction, no, sir. Can you just give more detailing, sir? Like what liabilities you're talking about in transferring to the bidder?
The business.
If you're doing a going concern, even
concern, all liabilities also will be.
No, sir, even in going concern, the liabilities are dealt with under 53, sir. Only the assets are transferred per se.
Sir, asset is there.
Sorry,
Zero
sir.
are there. Liabilities are 12 crores.
Okay, liability you mean creditors only, no, sir? The claimants.
Yes, sir. Shall I have to put it in BankNet, sir?
On online portal while
No,
uploading.
I understood, ma'am. I understood.
Yeah.
But per se in BankNet, we will list the assets only, sir, which we are putting up for sale. Are you like how are you monetizing this liabilities, sir? Like, are you putting it for are there some income tax accruing accumulated loans or something like that? Accumulated losses?
Yes, sir. ESI, GST, income tax, sir.
Okay.
All these are liabilities.
Liabilities, correct. But I mean, my point is, how are you going to generate liquidation assets, sir? These are only for the purpose of distribution, no, sir. So in BankNet, ideally, we only have to provide the details of the assets which we are proposing to sell. If the company has no assets, then
I have contingent assets, sir. Suppose I got an order from the NCLT to recover 2.72 crores, sir. It may
got it.
realize or may not realize.
Yes.
Another thing is perfect transactions. We have filed one case.
Okay.
That it may also take some time, sir. Right now, company valuation is 0.
Okay.
These are contingent assets. These type
So
of
only this contingent asset details you should provide on the banknet if you want to monetize this at a lesser reserve price value or whatever. Otherwise, liabilities per se, the banknet will not mandate. But if you want to provide, you can add the details. But liabilities is for us to deal as a liquidator.
No, now party other side is purchasing the asset through banknet.
Okay.
How can he is taking my assets, but he is not taking my liabilities.
Sir, sir, I mean, I will
Mr.
explain
Mata,
How can-
just a minute, Prakul, please wait.
yeah.
Mr. Mata, please put your question on IPNet website if you are a member of IPNet, and we'll
Yes,
take care of that.
I will put, sir.
Okay, thank you very much. Swasni ji, please.
Yes, sir. Now I request Parag Singhal sir to kindly give vote of thanks to our lead speakers, and I'll just share the memento.
Yeah. Thank you, Prakul ji, for your wonderful deliberation on section 29A, taking up the questions so patiently and enlightening us this forum and sharing your experience. Please allow me to share. Yeah, it is already shared.
Yeah,
so this will be delivered to you at your office by IPNet South as soon as possible. And thanks once again for joining us and taking out time to deliberate upon the issues.
My pleasure, sir. Thank you, sir.
Coming to Lalit ji. Lalit ji, thanks for your crisp presentation on section 29A. I'm pretty sure that your views have resonated with all the participants and the pain the IPs are facing so far as section 29A compliance is concerned. Please accept our gratitude and
thanks. Thank you. Thank you very much. Thank you very much,
allow me
sir.
to share your certificate, and it will be delivered to you through IPNet South.
Thank you. Thank you very much, sir.
Thank you very much. Thank you, Swasni.
Thank you, sir. Now I request Shri Rajiv Kumar Agarwal from IPNet East to announce the next week's webinar.
Thank you, Swasini. We are excited to bring
Sir, your voice is
knowledge series continues in the insolvency ecosystem. Saturday, 12th July 2025. Timing is 4 to 6 p.m. And topic is Smart Tech Revolution, Transforming Forensic Accounting and Audit in Insolvency.
Rajiv,
as technology, yeah.
This seminar is on next Saturday, if I am not wrong.
Yeah, next Saturday, 12th July.
Okay, it is on 12th July. Please announce the topic of the webinar again.
The topic of the webinar is Smart Tech Revolution, Transforming Forensic Accounting and Audit in Insolvency. As technology rapidly reshapes financial investigation, this session will deal into how AI, blockchain, data analytics, and automation are redefining forensic audits and due diligence process, especially in the domain of insolvency and resolution. Whether you are an insolvency professional, auditor, lawyer, banker, or forensic expert, this session will offer practical insights and emerging trends that you cannot afford to miss. Link for registration participation will be shared shortly. Stay tuned and block your calendar. Thanks. Thanking you.
Thank you. Thank you, sir. And now I request IP Pavitra Vyas to kindly give vote of thanks to the speakers and the participants and IPNet.
Thank you, Suhasini. Good evening once again. It is an honor to extend the vote of thanks for today's webinar. Today's event has been a good learning experience for all of us. So far regarding Section 29A red flags, legal interpretations, and what IPs must verify. First and foremost, I extend my heartfelt thanks to our distinguished guest speaker, Shri Charan Singh Ji, and lead speakers, Mr. Prakul and Mr. Lalit Mathur, for sharing their profound insights and practical perspectives of Section 29A diligence. Thank you, Charan Singh sir, Mr. Prakul, Mr. Lalit, for sharing your time, wisdom, and experience. I would like to express my gratitude to our IPNet President, Mr. Ashish Makhija. Ashish sir, your commitment and visionary leadership has made IPNet an exemplary initiative and a platform of great significance for insolvency professionals pan-India. Thank you for being a guiding light to all of us. A special note of appreciation goes to IPNet South for successful smooth conduct of this webinar. Special thanks to our invaluable contribution of transition and the technical support teams. Their seamless coordination and tireless efforts behind the scene ensure smooth conduct of the webinar. Our gratitude to all the participants who have joined us today. Your enthusiasm, active engagement, and thought-provoking contribution has truly made this event special. And last but not the least, our sincere thanks to Suhasini for IPNet South for taking out time for her ongoing courses for ensuring the success of this webinar. Thank you all once again.